towards the end of this session, and I just wanted to ask this one question. Can you maybe give us a little primer on the interplay of the two different types of support?
Well, when there is a family child support, just put it simply, it takes precedence. So,
right.
I mean, when I was referring to the software, or if somebody's going to go on online to search child support and spousal support,
Yeah.
Plugging in incomes will show that first is child support, and sometimes that difference in income, it's not, even if it shows what Eva was mentioning, 30-40 grand difference in between the recipient of child support and the payor, may not be sufficient for spousal support after child support is payable. So sometimes there may not be, for lack of better words, enough money to go around for spousal support. One may be entitled to spousal support had there not been child support, but because child support takes precedence, obviously, then spousal support may be completely off the table, just by mere fact that there's not enough money to go around. So the software or the formula is trying to, at best as possible, equalize the footing in both of the households and get to as close as possible of similar net disposable incomes for the payor and the recipient. And if that is achieved by paying the child support and there's not enough for the spousal support, then spousal support is doesn't even pop up. So it's a lengthier conversation, because that in that iteration, there's a lot of creative models that family have adopted to take into account not necessarily what a software or the legal rules dictate, but also what they feel is fair for their sense of fairness moving forward as a family, right? So child support, it may not be spousal support coming up in the software, but they both agree that spousal support should be payable, right, on top of the child support because of these and these reasons. And that's when you can have a more in-depth conversation about family's sense of fairness moving forward.
You've answered my very last question without me even asking. That's great, because I was going to bring in how mediation can help in terms of creative, like thinking out of the box. Because I guess what I'm trying to say is it's just very interesting that just now you're mentioning how sitting down and just having a calm discussion and working things out can actually be more fair to the couple, to the family unit, than the adversarial process of litigation. Right. You mentioned the spousal support guidelines. Is that the law?
So the spousal support guidelines are exactly that. They're guidelines. They're not hard and fast law, but they're essentially guidelines that are there to help the courts consolidate the rules when it comes to spousal support. So really, the law with spousal support, unlike any other area of the law, is very subjective. It says, look at these factors and decide for yourselves. The spousal support guidelines reemphasize that, but narrow the field a little bit more. So from the spousal support guidelines, that's our software, gathers from the spousal support guidelines, income, length of the relationship, and then provides us with a range of monthly spousal support or lump sum spousal support. So instead of just saying, okay, decide a number on your own, the spousal support guidelines at least consolidates it a little bit more and gives you some parameters to negotiate. A judge doesn't have to consider them, but the majority of them do, and it's very rare for a judge to deviate from them.
Okay, so Laura has one.
And I do have one more point to add.
Yes.
So while the guidelines are guidelines, they also should not be confused for entitlement. So that doesn't mean that someone is entitled just because the software spits out a number.
Right.
First, it's a two-step process. First, there has to be some kind of an acknowledgement or agreement that there is an entitlement, and then you can use the software and spit out and talk about amounts. But I oftentimes find that families, when they come here or they come to mediation, when they go to court or lawyer-led negotiation, they feel that the entitlement is already there just by the mere fact that the software spits out a number, where in fact that's not the case, right? The entitlement has to be found first, and the guidelines are not necessarily dictating that that's entitlement. It doesn't say that you're entitled just because you're using it.
So speaking of litigation, I just one last question. I wanted to ask you. I think you mentioned that software, which is Divorcemate. I think that's what it is, right? Or something like
Yes.
that. Do judges use that as well, or like how? Because I'm just wondering, do judges go home and they kind of like look use the Divorcemate and they kind of do those calculations themselves, or do the lawyers do all the calculations beforehand and they say, oh, we did all the calculations and the low, medium, high numbers are this, and so please make a decision as to what the amount is. So is it more like that second method?
Generally, yes. Yes,
Okay.
generally, the courts won't run their own Divorcemate. You may get one judge that really is interested in it, but no,
Right.
the lawyers would do their own Divorcemates
I
and
see.
provide them to the judge. I have seen judges look them up, or they've looked up the Spousal Support Advisory Guidelines, the actual guidelines.
Right.
But it's the judges prefer when a lawyer would do it. In mediation, every mediator is different. Me and Laura feel very comfortable running it for our clients. So we run it for our clients. Some mediators don't feel comfortable, and instead other individuals, they would have their lawyers run it and they would bring it to the mediator. So when you're talking to a mediator, you can always ask them, do you run Divorcemate statements? Can you do it for us? Or do you want our lawyer to do it?
Okay, so Laura, so that you just triggered a follow-up question to what you just said. Is it possible for couples who cannot agree on the entitlement issue that they can go to court just to have the entitlement issue decided, and then to save money, they can, like, whatever the judge decides, right? The judge decides, yes, there's entitlement, then they leave the courthouse or whatever, and then they go off on their own, or they go work with you to find the amount of support, like sort of break up the process. So go to court to figure out whether there is entitlement, and once that's decided, come to an agreement on the amount of spousal support outside of court. Is that possible? Can you do that?
Certainly. Yeah, I mean, you can break it up. However, I always look at the holistic sort of cost analysis. So breaking things like this up can really eat up emotionally and financially at everything, including the family pot of money to split and provide spousal support from. But certainly, yes, certainly you can break up anything you want. Yes, a judge can determine entitlement, or an arbitrator, right? So there's another process, could be a mediation arbitration process, where someone is going to make a decision at the end, and all factors are going to be considered in terms of the entitlement, and then we're moving right into the amount without any break in the matrix.
Right. And so for our viewers, if you don't already know, and I want to do a reminder that Laura and Marty, you guys did actually a video for us on mediation arbitration. So I'll put a link to that. Of course, I'll have a little button at the top somewhere here so that people can refer to that video when they have time. Okay, so thank you so much for joining us today, Laura and Eva, and thank you everyone for watching. Please consider supporting our channel by subscribing and sharing our content. And also, you can connect with us on Facebook and Twitter. So see you next time. Bye.
Bye.
Bye.